Welcome, everybody. Sorry about that. System issues always giving us fun. Welcome. I'm really excited for today. Again, back with my partner, Michelle Dexter, for a topic that everybody wants to avoid except you guys. Congratulations. You guys are the winners for the real prize, because this is something that when I first started in this industry, I was actually really surprised to hear that this is something a lot of places don't even talk about, don't even know about. And in fact, I just had a phone call from someone, and I got on the phone with him, and he said, I just read an article on your page about funding your trust. He's like, what is that? And so I gave him the 2-minute version, and he's like, okay, I need to break it to you. I'm a lawyer here in town. I had a partner of mine do my trust like 5 years ago, and they never told me about funding my trust. Are you telling me if my house and my bank accounts and my investments are not owned by my trust, that they are still going to go through probate? I said, yeah, they are. And he was fuming, furious. And I just hear it over and over and over again. People don't talk about this, about how important it is to fund your trust. So you guys are here to get the nitty-gritty details on how to actually do that for various different types of accounts, investments, real estate, everything. Michelle's going to blaze through it. We are recording this so that we can share this with folks who weren't able to make it today. And we have also built our process to get these posted onto our YouTube channel so that we can just share these publicly wide and large. So please don't share anything in the chat or when we open the Q&A, anything that you don't want to share. Obviously, your private information we want to keep private, but if you have a question, make it generic so that it can benefit everybody and you can get your questions answered. And then we will also be sharing the link to next week's webinar. I invite you guys to join that. That is with Carmi Gutman, who's the CFP with lifestyle planning. And on that one, he's actually going to walk through a couple different annuity statements to show you just how to read an annuity statement. So if you have an annuity, you think you do, you're not sure if you do, that one's going to be really helpful and practical as well. But with that, I want to thank Michelle for putting this together and coming up with all the information and sharing her wisdom with you guys. And I hand it over to Michelle Dexter.
Thanks, Francisco. I'm so excited. Thank you all for giving me your time this afternoon. I see a lot of familiar faces and a lot of new people, so that is fabulous. We are a firm believer that you have to hear some of this stuff about 7 times for it really to start to sink in and for you to become familiar with it. So kudos to you for taking some time today to do some of that. When I first started here, I'm actually about to celebrate my 8-year anniversary here at Keystone. When I first started, we would do people's trusts. We would talk to them about funding, send them on their way, and then they'd come back a year later to review, and we'd say, how did funding go? And they'd look at us like deer in headlights, like we just said something they'd never heard before. So over the years, we have tried to improve our process to help our clients understand what funding is, to understand how to accomplish funding, and to constantly review funding, because even though you may have done it in the beginning, like most of us, we change out assets, we move our bank accounts, we do all those types of things. So while creating your trust feels like a big accomplishment, you know, you picked your agents, you decided on your beneficiaries, you outlined your vision for distributions, there was still work that lies ahead. And for those of you that have a trust, you know some of what that looks like, and it's always good each year to just review your assets and make sure that they're funded properly. For those of you that don't have a trust and are like, I don't have a trust because I don't understand this funding stuff, hopefully we're going to help you today to kind of understand that type of thing, okay? We know that people can be confused about funding and often are hesitant to create an estate plan because of that, and they just don't know how this is going to disrupt their management of finances and handling of their money. So hopefully we'll cover that for you guys today. Funding, that term is essentially converting your accounts from your name into the name of the trust. Okay, so my checking account got changed from Michelle Dexter to Michelle Dexter as trustee for Michelle Dexter's trust. All right, I still am managing it. I'm trustee of my trust, so I still manage my assets, My bank account is still using my social security number. We'll talk about all those things, but the actual act of funding is not changing where you bank. It's not changing how you manage your assets. It's not changing a whole lot. It's just updating the people that maintain those accounts with the current information so that they know it's no longer in Michelle Dexter's name. If something happens to Michelle Dexter, we don't have to go to a conservatorship or a probate. It's in Michelle Dexter's trust. And if something happens to Michelle Dexter, next man up, the next trustee steps up. Okay. So when you're converting your accounts into the name of the trust, it's not triggering any kind of taxes, and you shouldn't generally have to change where you hold your accounts or who manages them for you or how you invest them. Okay. I want to start with the biggest asset that most of us have, which is our real property. Okay. When we have a home or a piece of land or a second home, there's two paths that we can go down with funding our home into our trust. Okay. The first path is where most of us have a mortgage on our property. Okay. When we have a mortgage on the property, what we do is what we call a beneficiary deed. And the beneficiary deed says, if I pass away, it's going to go to my trust. All right. Now, if you're a married couple, it might say if one of us passes, it goes to the survivor of us. And when we both pass, then it goes into the trust. And at that point in time, your trustee, your successor trustee, can take care of the mortgage, whether we're selling the house or we're paying off the mortgage or we're trying to get somebody to assume the mortgage, whatever it is we're doing with the mortgage at that point in time. Okay. Your trustee can do that. And with that beneficiary deed, we are avoiding probate of the house and can make sure that it passes to the trust smoothly. All right. We don't want the mortgage companies to call the loan. A lot of times our loans have more provisions in them that say, hey, if you transfer it out of your name, we can call the loan. And while technically they're not supposed to when it's transferred to your own trust, most of us don't want to get the call that they're trying to change our 3% interest rate to a 7 or 8% mortgage rate. And so I don't want a bunch of angry, panicked people trying to do that. So we do the beneficiary deed. Okay. So that is one way that does get recorded with the county recorder's office. It is a document that you can go back and change if you want to, but you are still the owner of that property. And during your lifetime, if you became incapacitated and we needed to sell it, we would be relying on the power of attorney to sell it in your name. We run into less of a problem with the title companies than we do the financial institutions with the power of attorney. So that's not that much of an issue to get the house sold if we needed to, if you were incapacitated and there was just a beneficiary deed. But a lot of times I get clients that come back and they're like, I just checked the tax assessor's office and the house is still in my name. How come it's not funded? It's because there's that beneficiary deed on there, and that's not going to show up on the tax assessor's statements. That's going to show up in your binder with that beneficiary deed. That's going to show up in the recorder's office. All right. If we don't have a mortgage, we can put the house right into the name of the trust. Okay. And that's a great way to just make sure that we're covered on all areas. When you're titling your house to your trust immediately, you want to make sure that you are adding your trust as an additional insured on your homeowner's insurance. Okay. The purpose of that is if something happens to the house, and I work in worst case scenarios. I think those of you who know me know I'm great at killing off your whole family in these conversations, right? You go up in a blaze of glory with the house, and so do your documents and everything. Your successor trustee needs to step in and make that claim with the homeowner's insurance. If the trust isn't named as an additional insured, they may have to open up probate to file that insurance claim. So call your homeowner's insurance, add the trust as an additional insured on that if your house is titled to your trust right away. Okay. One thing that I've found over the years is that we've had clients that have a house, no mortgage. We put it into the name of the trust. Great. Everything is taken care of. And then a few years down the road, they say, you know what, I want to take a loan against the house. I want to improve the kitchen or the bathroom or put a pool in or do whatever it is that you guys want to do. You go to the mortgage lender and they decide they don't want to make a loan to you with the house in the name of the trust. They want to make a loan to you in your name. And they then pull the house out of the trust. Okay. Now, that's not necessarily a bad thing, except for the fact that the mortgage companies never say to you, now put a beneficiary deed on it, or put it back into the trust, or take some action to avoid probate with it. So that, again, is one of those reasons that we want you to be reviewing your documents on an annual basis, because you may not realize that getting that loan actually unfunded your house from your trust. Okay. And so it's just a good thing to just kind of double check and make sure that you didn't take some action during the year, or that they said they were going to put it back into the trust and then never did, because I've had a few of those as well. All right. One thing that I'm going to add for those of you who are here in Maricopa County, let me see if I can add it into my chat notes, is here in Maricopa County, we have this title alert system. And you can register with them, and they will notify you if there are any changes with regards to the title to your property. And so that's just a kind of a good fraud prevention type of thing. I don't know if any of the other counties are doing it, but definitely worth checking if you're not in Maricopa County to see if any of the other counties where you own property have something similar, because it's definitely nice to get notices type of thing. Okay. So that is basically funding your house in a nutshell, right? We're either doing that warranty deed, or we're doing a beneficiary deed to make sure that upon your death, the house is in the trust. Okay. The next thing which is probably like a big concern for people, is their personal property, your furniture, your jewelry, some of those prized possessions that you have that don't really have a title to them, right? They're not recorded in the recorder's office. They aren't held by a bank, those types of things. When we do our estate plans, we do an assignment of personal property with that says all of those assets are to be considered as trust assets, and your trustee has authority over them. Okay, so that's a pretty simple way to make sure that we're just kind of catching all those assets. I want to encourage people, though, that when you have personal property, especially if you have family heirlooms, if you have special care items with significant values, put information about that in your binder. In our binders, we have a trust asset section. You can put information there. We don't want to rely on people's memories because it may not be the most important thing to them, and it is important to you. In addition, you've got typically a line of 3 different potential successor trustees. Any one of them could be handling those assets. So instead of trying to get 3 people to remember, put some information in the binder. Take a picture. Hey, this is my diamond engagement ring. It is the real deal. Everything else I own is costume jewelry. So don't worry about that, but worry about this type of thing. Okay. And that's just a great thing to go ahead and put into your binder with regards to that. But the funding of your personal property is pretty straightforward. Okay. The next big thing are bank accounts. Okay. Now your checking account, your savings account, those types of accounts ideally will be titled in the name of the trust. Okay. That eliminates our need for a power of attorney if you become incapacitated. It eliminates our need for a probate after you pass away. Certain big banks, Wells Fargo, Bank of America, some of those banks will allow you to just convert your account from your name into the name of your trust without changing the account number. Okay. Now, maintaining that account number is important because we are very spoiled nowadays with automatic deposits, automatic payments that come in and out of our bank account every week, every month type of thing. And so we don't really want to have to mess with that if we don't have to. So those places are very easy. You go in, you take your certificate of trust, they update the account to reflect your trust name on it, and you can continue using your checks, your debit card, everything remains the same. Okay. Our friends at Chase, however, they don't have the same theory on this. And so basically with Chase, they have said, oh, for us to change it from your name into the name of your trust requires us to give the account a whole new account number. Okay. And so when we're dealing with those automatic deposits and withdrawals, that is a major burden for most of us. So when that is a situation, now, if you've got a savings account at Chase that doesn't have automatic deposits and withdrawals, just go ahead and open, put that into the name of the trust. Don't worry about the new account number. But when you've got those automatic deposits and withdrawals, I'm not going to ask you immediately to convert all of that to a trust account, but I am going to ask you to, at a minimum, name the trust as the payable on death on that account, so that if something did happen to you in terms of a death, we could transfer that into the trust immediately without having to go through probate. Okay. We run into issues when it is, during your lifetime, that account's still in your name. We're relying on the financial power of attorney. If you've talked to me, you probably know that the banks have a lot of discretion when it comes to those financial powers of attorney. They have lots of reasons that they want to reject them. And one of the main reasons that they typically give us is that they consider the document to become stale. Our rule of thumb is 5 years, although recently I'm hearing more and more about some institutions saying that it's stale after 2 years. So if you are knowing that your financial power of attorney may need to be used in the near future and you haven't updated it recently, if you're starting to show signs of an incapacity or having a major health issue, if you're going to go out of the country for a couple of months, it may be a good time to just review that financial power of attorney and update it for any of those assets that are still in your name during your lifetime. Diane, I see your hand, but we're going to hold questions until the end. Okay. Thank you so much. Some institutions require special qualifications to be a member, like USAA requires some military experience. And so they typically tend to be very hesitant to put that into the name of the trust. Same things with a lot of the online accounts. I don't know if they're worried about fraud or why, but a lot of those types of accounts don't want you or will not allow you to put your account into the name of the trust. Name the trust as the payable on death so that we can avoid probate. But then I also want you to consider, if that institution refuses to accept your financial power of attorney, how much money is in that account? How badly do your successor agents need to access that account? Is there money in other accounts that they'll be able to access more easily? Or is everything tied up in this one account and this is going to be like their make or break type of thing? So when you are kind of looking at your overall financial situation, that's something that you just kind of want to look at and determine, how important is it for me to have this account at USAA or online? How much money do I have there compared to the rest of my money? And if something happened to me and they didn't accept my financial power of attorney, how burdensome would that be on my successor agents? Okay. Just going through my notes. Sometimes we get people that are like, I'm just going to name my kid on the account. Okay. So there's a couple of different ways that banks do that. One is they might just make them a signer on the account. Okay. And when they're a signer on the account, those privileges terminate at your death. Sometimes they'll terminate at an incapacity. And so it may not work out quite the way that you're thinking it's going to. And it could still lead to a conservatorship because that account's not titled in the name of the trust. The other way that they do it is they might make that child a joint owner of that account. Okay. Now, when they are a joint owner of that account, they are not necessarily obligated to share that account with your other beneficiaries. Okay. They are technically an owner. And so that sometimes can backfire on people. Other times they're like, well, I'm naming this child as an owner on the account and I've instructed them to share it with the others. And, a lot of times we can trust our kids. I'm not saying you've got untrustworthy kids, but we can trust our kids to follow through with doing that. The problem becomes that depending on the amount of money in that account, the joint owner is the owner of that account. When they go to make a distribution to those other beneficiaries and they're sharing that money, it's technically a gift from that child to the other beneficiary. Okay. And if that gift is over $19,000 this year, that is triggering a gift tax return. Okay. And so a lot of people don't necessarily think about that. They just think it's going to be simple. I'm going to keep it easy. I'm going to let this kid, they're going to be in charge of it and they're going to handle it all for me. But they don't realize that that's technically a gift. It may not actually trigger a tax, but it should trigger a gift tax return, which is additional money and burden on those people that could all be avoided by the account being titled in the name of the trust. Okay. You also want to be very careful that when you're naming your kid on an account, if they're going through a dissolution of their own marriage, if they've got a creditor issue, if they're being sued, they're an owner of your account. That money is subject to those types of lawsuits. And so, while we hope that never happens, the reality is that it does happen on a regular basis. And so we just want to make sure that you guys are being careful and cognizant of what that means for them to be a joint owner versus they're a successor trustee and the account's in the trust. And if something happens to you, they can step up as successor trustee. Their obligations are still to you guys. And it's not their money. It's not subject to their own personal liabilities. Okay. A lot of times online accounts, cryptocurrencies, those types of things won't have options for holding a title in the name of the trust. Make sure with your cryptocurrency that you're storing your login credentials, your passkeys, your wallet codes, or whatever on paper someplace. You can put that into your binder. Those are the types of things that, if you want it scanned into our matter, you don't have to give us the full details of like, I've got cryptocurrency with this company and here's all of my information, but you just say, here's some important passcodes that they're going to need, right? And then we won't know what it's tied to. Only your family will know what it's tied to. We had a client a couple of years ago. Her son, who was, I think he was in his 30s, passed away kind of unexpectedly. She didn't even know he had cryptocurrency until the IRS sent her a tax statement and said that she had a big tax bill. It took her quite a few years. In fact, it took her several years to finally find the piece of paper that he had with that passcode in it. He had $600,000 in that cryptocurrency account that was almost lost because she had no way to access it, but for luckily finding this piece of paper with that information on it. So I know cryptocurrency is kind of all the rage, and I wouldn't ever tell somebody how to invest or not invest in things, but definitely those types of things you have to be really careful with because they're really sensitive to the particular information and are not they're not subject to a local lawsuit. They're not subject to finding another way into it. So you got to be really careful with that. Okay. In general, when you're looking at your bank accounts, I want you to make sure that you're looking at, if not everything is in the trust, how much is in non-trust accounts? What is the likelihood that your agent would need to access those non-trust accounts? And how much difficulty could they possibly have to access those? Okay. Now, separate from your checking and savings accounts are your traditional brokerage accounts, right? So the first thing I'm going to say to you is, do you have a financial advisor? If you have a financial advisor, they can generally be very helpful in helping you get your accounts titled into the name of the trust, okay? Our brokerage accounts don't typically have automatic deposits and withdrawals, so whether or not they change the account number is less of an issue, right? Your financial advisor can definitely help you with getting your account titled to the name of the trust. If you don't have a financial advisor, let us know. We'll be happy to, have you talk to somebody. Your traditional investing accounts, your brokerage accounts are not retirement accounts, okay? These are more of your cash accounts that you can pull money in and out of more freely than your retirement accounts. We'll talk about retirement accounts in just a couple of minutes, but your brokerage accounts, you definitely want those titled in the name of your trust. Those are bigger tickets items. They are going to trigger a probate in most situations, and they're going to be the money that we need to access in the event that you become incapacitated and we have higher medical bills, or we need to access money. Okay, so brokerage accounts in the name of your trust. Next, we've got vehicles. Most people prefer to leave their vehicle in their name as individuals. That's not much of an issue. That reduces the need to name the trust on the insurance for the autos. It reduces an issue if you get into a car accident and you're exchanging, insurance and registration information. Here in Arizona, the Arizona Department of Transportation, or ADOT, has a beneficiary form. Okay. It's very simple to fill out. It doesn't require a notary. It doesn't require any kind of special stuff. And we keep it right in the binder. Okay. If you still have that vehicle at the time you die, your successor trustee can take the ADOT beneficiary form to ADOT and get the title issued in the name of the trust at that point in time. A lot of us change out cars. Well, not me. I like to hold on to my cars, but a lot of us will trade out cars every few years. And so it can be burdensome putting it in the name of the trust. It's less of an issue with vehicles because ADOT tends to take the general durable power attorney. We're just not running into the same problems. If you're leasing a vehicle, you don't own the vehicle. You're not going to own the vehicle at that point in time. You don't need the beneficiary designation. If you decide to title it to the trust, and The exceptions that I do sometimes use are if you've got a classic car, if you've got something that you drive only on occasion and it's got some serious value to it, that might be worth putting into the name of the trust. Just make sure that if you're titling it to the trust that you go ahead and add it to the insurance like you would the house. All right. Life insurance is another big ticket item. The life insurance, you remain the insured, but we can name the trust as both the owner and as the beneficiary. Okay. Now, I like to name the trust as the owner of the account because if the premium on that insurance policy starts to go up, if your financial situation changes, your trustee can make the decision of whether or not it's still a smart decision to maintain the insurance policy. Okay. And so that's the purpose of naming the trust as the owner of the policy. We like to name the trust as the beneficiary of the policy. There's no tax consequences with life insurance when those get distributed, but depending on who your beneficiary is, your beneficiary could run into some issues. If your beneficiary is under the age of 18, the life insurance company is going to require a conservator be appointed for them before they distribute those funds. If your beneficiary is incapacitated, if you have beneficiary protections in your trust and you're protecting the assets for your kids, if you've got special needs language, if you've got a whole variety of things, your trust is going to handle that, and it's going to have all the contingency plans in it. So naming your trust as the beneficiary, even if your spouse is still alive, your spouse is still the primary beneficiary of most of your trust. So you can name the trust as the beneficiary of your life insurance and have all of that flow through. Again, if if your spouse is incapacitated, if we have to distribute to him or her, the life insurance is going to require a conservator be appointed for them. If it goes in through the trust, your trustee is managing that for them, and the life insurance is not worried about a conservator. So naming the life insurance beneficiary and owner can really be helpful. Next, for those of you that have business interests, if you have an LLC type of thing, this is a great way to name your trust as the owner of it by naming the trust as a member. Here in Arizona, we have the ability to have a member managed or a manager managed LLC. What I like to do is do a manager managed LLC. The managers are you guys as individuals. The member is your trust. If something happens to you guys as the managers, the trust can name a new manager to wrap up the LLC, to sell it, to do whatever they need to do with regards to the LLC. And that's an easy update with the Arizona Corporation Commission. Okay. Now, if you have a shareholder's interest in a business, that can be a little bit more difficult because that may be dependent on what that company's rules are. And so a lot of times you're going to need to reach out to the specific company that holds those shares to determine, can it be titled in the name of the trust? Is there a way for me to name a beneficiary? How do they allow you to avoid probate with regards to those shares? Sometimes some of those shareholder interests can require a medallion stamp signature. Those of you not familiar with the medallion stamp, it's like a notary stamp all jacked up. It requires very specialized people to do those. A lot of times the financial institutions will do them, but I'm finding that a lot of them are limiting how many medallion stamp people they have. And so it may be that Bank of America does it, but only this one branch in the East Valley does it. The medallion stamps also require you to provide a lot of documentation in advance. So going to get a medallion stamp signature may require several trips to the bank. And so if you need a medallion stamp, I recommend that you call around first, make sure that they have somebody, find out what documentation they're going to need. They'll have their legal department review and approve the documentation before you can sign before them, and they can just be really burdensome. So definitely don't delay on some of those things. Try to get that going as quickly as you can. If you are in a partnership, you may have a partnership agreement, and that may be able to be updated to reflect your ownership as a trust or to update as a beneficiary designation. Those of you who might have S corps, this is technically a tax status versus an ownership type. Trusts can only have an interest in an S corp for up to 2 years. Okay, so you may not name the trusts as the owner during your lifetime while you're operating it as an S corp, you may just name it as the beneficiary so that your successor trustee can wrap up that business or transfer the business or sell the business or do whatever things that they need to do in that 2-year period. If you have an S corp, please make sure to let us know and let us make sure there's additional language that we like to put into the trust to deal specifically with S corps. And so we would just want to confirm that that's in there. All right. If you have oil and mineral rights, some of you still have oil and mineral rights, and they can be almost as big of a pain as the medallion stamps. You know, you get a $3 check once a year. You don't really know where that's coming from. You don't know who to contact. They're not giving you any information. Those types of ownership interests can be either in the form of a deed and can require the filing of a deed in that state where those oil and mineral interests are. Generally, we don't see them here in Arizona, but a lot of times in Texas or Missouri or Kansas and some of those types of states. Sometimes you can go and the company itself will allow you to put some kind of beneficiary designation on them. They're often people that you have to chase down and can be pretty burdensome. But in the long run, like if you can get into the trust, it can be held in the trust a lot longer than as an individual and continue to have that issue. Okay. But they're definitely a little bit of a beast to deal with. Now, your retirement accounts stay in your name during your lifetime. That's part of the IRS rules for retirement accounts. You want to name individuals to avoid probate, but generally we're not naming your revocable living trust, okay? Back in 2020, they passed the Secure Act that said that individuals that weren't under a certain group got 10 years to pull the money out of retirement accounts. A trust gets 5 years, okay? And not only does a trust only get 5 years, but it gets taxed at a higher tax rate with a lower threshold. So you could be at almost a 40% tax rate with only about $15,000 in income. And so for most situations, the revocable living trust is not the way to go in terms of naming a beneficiary. If you have, if you don't have other people, if you have a Roth IRA that doesn't have a tax benefit, I'm less worried about you naming the trust as a beneficiary because we're not dealing with tax issues there, right? But if you don't have another alternative beneficiary and you're less worried about the tax issues, you can name your revocable living trust. If you have concerns about your beneficiaries receiving the money, they've got special needs, they've got various issues, or you just have a whole lot of money and you want more protections around the money coming out of retirement accounts, there's this document called the Standalone Retirement Trust, and we can have a whole separate webinar on that. But just in general, when it comes to retirement accounts, individuals are generally the way to go. If you're looking at a minor beneficiary, that may be the time that you're looking at either a standalone retirement trust or using this type of trust as a contingency plan, knowing the risk of the additional taxes and shortened period of time for that. Okay. Now, there are things that I often get asked about in terms of funding that actually don't get funded. So your mortgage doesn't get changed into the name of the trust. Your credit cards don't get changed into the name of the trust. Loans, all of those things are tied to you as an individual and based off of your personal credit and your personal income. So most places won't tie that to a trust. There are very few mortgage companies that will make a loan to a trust. They mostly want to do that to an individual. So you don't have to worry about most of those things and funding those. Those are things that, especially a mortgage is tied to the house. We're going to take care of that as part of the trust and taking care of everything after you're gone anyway. Credit cards and other loans will also be taken care of in trust administration after you're gone. So I'm not terribly worried about that. The last thing that we don't fund is timeshares. For most people that have timeshares, they're more looking for a way to get out. And so we don't want to force that to go to the beneficiaries. If we tie it to a trust, the trust can have some obligation to continue paying maintenance fees on those types of things, versus if you just don't do anything, the timeshare a lot of times will try to reabsorb that. The only time we're looking at naming beneficiaries or the trust on a timeshare is when we know that the beneficiaries A, want the timeshare, and B, can afford it, and probably C, will use it, right? But my experience over the last probably 20 years with timeshares is that most people they might enjoy them, but don't necessarily want to pass them on to their family members, or their family members aren't really interested in maintaining those. So those typically don't get funded into a trust at all. Okay. So those are kind of my highlights of the funding for your trusts. I'm going to see if I'm going to look through the notes real quick. I see Wells Fargo does not offer medallion signature services. I'm not terribly surprised. I think that I think Fidelity might, although they don't have a lot of locations. Bank of America used to, but I feel like the last time one of my clients needed that, they didn't necessarily do that anymore, or at least the location that they went to. And so we were having them call around. There is now a mobile medallion stamp company or companies, and I think they charge you a few $100s to come out and do that. But sometimes that may be just kind of what needs to happen. So thank you, John. I appreciate you attending. And let's see. Oh, good. Pinal County also has a title alert. So definitely, if you've got property in Pinal County or Maricopa County, go ahead and do that. Susan asked, change the name of the banking account to what? So you will have a certificate of trust that says what the name of the trust is. Generally, it is Michelle Dexter, trustee of the blank name trust, dated such and such. Okay, so that's it. It can be kind of a long name, right? Now, on our certificates of trust, I've typically bold that language so that you know what it is that we're looking for naming those accounts. There's also language on our certificates of trust that say, hey, look, if they say to you this is way too long and they can't fit it in there, they can abbreviate it. They can use an alternate names. And so sometimes you'll see, instead of saying Michelle Dexter trustee, you might see Michelle Dexter TTEE for trustee. And you might see UTD under trust dated. And you might see there's different ways that they can do it. As long as they can identify the trust, it's perfectly fine. Okay. I do believe with Maricopa County that you have to register for each property, John. So I would definitely check on that. I only have one property, so I just did it for my one, but you could definitely make sure that all of them are covered under that. How do you make sure that your home is funded into the trust? It was refinanced after being put in. The property tax statement has trustee after my name. Does that prove it's in the trust? So here in Maricopa County, the best way that I typically do it is our Maricopa County tax assessor. Let me see if I can get the website for that real quick. The tax assessor's website, and I'll put that in the chat, allows you to search for parcels and addresses. And so I can put the address in there, and Pinal County has something similar as well. I put the address in there, and then it will pull up the address information, the APN. And if you scan down about 2/3 of the way through the information, there's a place that says, I believe, deed number. And if you click on the deed number, that will take you to the most recent deed on the property. And that ideally is going to show you that it's titled, that when you titled it into the name of the trust, or if you took a loan on it, where they took it out of the trust. And so that's generally the first place that I look when I'm looking to confirm whether or not a piece of property is still titled in the name of the trust. So hopefully that will help you with looking at yours. Is this information regarding what goes in the trust and what doesn't? I will check to see if that information is on our website. Alexis, who is joining this meeting today, will also help me with checking that. I'm glad to hear Desert Financial offers the medallion stamp, because that's definitely good. Sometimes, though, the banks will require you to be a customer of theirs for 6 months before they'll do the medallion stamp. So keep that in mind as well. John and Katie, we have a beneficiary deed for a house, but no longer have a mortgage. What is it again that we should have the insurance company do? So what you might want to do, Don and Katie, is first go ahead and move the house into the trust. So you would have a new deed recorded for the property. And in conjunction with that, notify the homeowner's insurance and have the trust added as an additional insured on your homeowner's insurance. Okay. Some people also like to notify their homeowners association so that those bills are coming to the trust versus them as individuals. I don't know how much of that stuff makes much of a difference in terms of with the homeowners associations. I think at the end of the day, they'll just want to get paid from whoever pays them anyway. whether or not they give you a hard time in terms of answering questions, I don't know. Alexis, thank you for adding the funding frequently asked questions on our website and that link there. So hopefully those of you who need that can get that. We can add the Roth IRA account to the trust, but it's not a good idea to add IRA retirement accounts to the trust. Correct. How about the 401k? Okay, so for those of you that aren't familiar, Roth IRAs are IRAs or retirement accounts where when you receive a distribution, there's no tax because the money that you put into it was already taxed. So the money you get out of it, you're not having a tax consequence. Okay, so we're not putting that into the trust because it has to remain in your name in order to continue to grow tax-free. But you can name the trust as the beneficiary on those because there's not going to be any kind of tax burden when that money comes out of the Roth IRA. Your traditional IRAs, your 401ks, typically when you are getting a distribution out of those accounts, you're also being taxed each year on that. Those are the ones that we don't recommend that the trust be named as the beneficiary because it can have shorter time periods, higher taxes, those types of things. Okay. Savings bonds held at the Treasury Direct. Yep. And the Treasury Direct now will allow you to put it into the name of the trust. If you don't put it into that Treasury Direct and you've got a beneficiary named on them, sounds like it's going to be her problem. Now, the thing that I always get concerned about, right, is, again, those of you who know me, I work in worst case scenarios. What if your daughter's not there to receive them? Okay. And so that's where, there's not a lot of contingency plans there with that type of beneficiary designation. And so if she's not there to receive it, then I worry about, is it going to end up in her probate? Is it going to end up in your probate? Is it going to end up going where you want it to go? And so that's where, at least I believe in Treasury Direct, you can have a couple of different contingency plans, but if you name it in the trust, you've got a lot of contingency plans and we know for sure it's going to go where it is that you want it to go. So I get that it's burdensome because I think especially some of those forms go like, you can only list like 5 or 10 of the bonds at a time, and then you have to do a whole new form type of thing. But maybe one of these days when it's 115 degrees outside and you've got nothing better to do, you can work on doing that paperwork, okay? Would it be a good idea to add an ESOP in the trust? I believe a lot of those employee stock option plans may allow you to name the trust as a beneficiary, but they probably won't let you name the trust as the owner, okay? And so you want to work with your individual company on that and see if they will at least let you name the trust as the beneficiary, because again, your trust is going to have all those contingency plans, and we really want to make sure that we're doing our best to avoid anybody's probate, whether it's your own or somebody else's, and that the money is going to go the way that you want it to go. So definitely reach out to your employer to see what their options are with regards to that. Okay. Good questions, everybody. And I appreciate the interaction with it, because otherwise it's just me talking to myself up here. So let's see. Any other questions with regards to annuities? So annuities, and Francisco mentioned at the beginning of the hour that Carmi is going to be doing a section on annuities here, I think next week or the week after. The reason that annuities are so confusing is because annuities can be one of two different ways. They can be like a life insurance where there's no tax consequence, and they can be titled to the trust, or the trust can be the beneficiary, and that's not a big deal. However, there's a lot of annuities that are more like a retirement account, and they have tax consequences, and they're going to be treated more like a retirement account. And those types of annuities, we don't want to name the trust, we want to name individuals. And so identifying the type of annuity that you have is really important. And that's one of the things that Carmi is going to do in that webinar coming up, because a lot of times, even looking at the statements, we'll have clients bring in the statements and I can't tell sometimes from the statements. Sometimes it will say on it qualified or non-qualified. It might say IRA on it. If it's qualified or IRA, we definitely don't want that to be something that goes through your trust because of the tax consequences. So thank you, Alexis, for posting that annuity webinar registration link in there for those of you interested about that. Because yeah, I had Carmi about a year ago sit down with me and a case manager and walk me through annuities to make sure that I clearly understood. So annuities are definitely a case-by-case type of scenario. Leanne's asking, should a self-managed health savings account be in the name of the trust? A self-managed one may be able to be in the name of the trust. Any of those types of assets, right, where if you were not able to manage it yourself, if it can go into the name of the trust, I would highly recommend that. Sometimes the health savings accounts want it kind of like the retirement accounts, they want it tied to that individual. And so we want to make sure that, you know, we're doing what we can to avoid probate and minimizing the issues. If they'll let you put it into the trust, please do. If they won't let you put it into the trust, find out if you can name the trust as the beneficiary for anything that might be left over in that. All right. Good questions, everyone. Good questions. Yeah, and if you've got an HSA through an employer, you're going to have to check with your employer. Most likely they're not going to let you title it into the name of the trust, but they should let you put a beneficiary and allow you to name your trust as the beneficiary on that. Okay. So, all right. So yeah, you know, check if you put all of the information about your assets into your binder. For our binders, we have a trust asset section. So we encourage our clients to put the information there. And then just once a year, you're just reviewing it. Are my accounts still at Wells Fargo? Do I still have this vehicle? Do I, you know, did I do anything different with the house during this last year? And then that way you've got an opportunity before it's too late to make sure that you're always making sure your funding is up to date with these assets. You know, things change. Sometimes, you know, you're at one place for a very long time and then suddenly you're not. So it's always good to review that. I had a client a couple of years ago that his mom had a bank account at this small bank on the East Coast. And he's like, I'm not going to put it into the trust because, you know, everybody there knows us. And I'm like, how long have you been banking there? He's like, 40 years. And I'm like, and what happens when those people retire and a whole new group of people come in and they don't know who you are? That definitely made him kind of reevaluate the need to put things into the name of the trust and why that was important. So definitely keep that in mind. Mike's asking if having a car in the trust make the entire trust liable in case of an accident. The trust is not an asset protection trust. It's a probate avoidance trust. So whether the car is in the name of the trust or not, your assets are subject to your liability. Okay. What we find is that people don't like the idea of giving somebody a registration that shows that it's in the name of the trust, because there's still a lot of false belief that having a trust means that you've got a lot of money versus you are smart enough to avoid probate. And so for some people, they don't want to give the false impression that they're more wealthy than they are, and have people that they've been in a car accident with think that this is a good opportunity to, you know, get something more than they should. Please comment again on the process to do a beneficiary deed for a primary residence with a mortgage. I would add the trust as a beneficiary. Correct. Yes. So there's a separate document called a beneficiary deed that says that upon your passing, the property goes to the trust. The beneficiary deeds have to have the name of the beneficiary on the deed, right? And so for those of you that have a trust, you are the current beneficiaries of that trust. Okay, so you put down your own information. I'm not worried about your contingent beneficiaries. Those may change. So, you know, Michelle Dexter, if something happens to me, it goes to my trust. I am the beneficiary of my trust. Here's my information. And so then you record that with the county recorder's office. Okay, hopefully that helped you there, Ron. Do we have to notify Social Security of trust name? Nope, your Social Security is in your name as an individual. That's not something that we can change. Where your Social Security gets deposited, right? That's where we want the trust in play. So your Social Security is automatically deposited to a bank account. That bank account should be in the name of the trust. Okay, and so that's the only thing that you're notifying Social Security about, is what account to put that deposit into. For those of you who haven't experienced Social Security after the death of a loved one, they are amazingly effective, I guess, at making sure that they claw back that last payment if appropriate. And so they're one of the few government agencies, in my opinion, that is very efficient at handling that type of thing. So they will definitely make sure that they claw back that last payment if you're not entitled to receive that whole thing. So just a little side note on that. Do you have time to speak to a charitable remainder trust? A charitable remainder trust is a whole different beast, and definitely I will mention it to Francisco about having a webinar on that, because that is there he is. That's definitely a good topic, not necessarily applicable to everybody in the room, but definitely is a very interesting method of protecting assets for your kids and benefiting some charities. And I don't know if you have anything you want to say to that note, Francisco.
No, just that we'll be happy to do a webinar on it. I touched briefly on it in one of the prior ones, but it's a whole topic on its own. So yeah, we'll put that on the schedule.
Yeah. Thanks for the idea, Leanne.
Yeah.
All right. We had a lot of really great questions, Francisco.
As trust funding usually brings. Great job.
Well, and hopefully, again, you have to hear this so many times, and it's one of those things that you think you funded, but you want to go back and review periodically. You want to make sure that as you're changing where your bank accounts are held, or you've gotten a new asset, and so you went and you inherited some money and you went and opened up a new account to keep that money in. Was that titled to the name of the trust? You just constantly want to think about that. And for those of you, again, who have done their trust with us, there is a trust funding tab in our binder. And in the beginning of there is a generic list of the different types of assets you could have, whether the trust should own it, whether we should name a beneficiary. And so anytime you're thinking about acquiring something new, whether it's a new account or a new asset, double check that list. If you don't think it's clear there, reach out to us. We're happy to answer those questions, but we definitely want to make sure that your trust is fully funded and avoiding probate. So
Amen. That's the whole deal. Awesome. Thank you, everybody. And thank you mostly, Michelle, for the great stuff. If you need to watch this again, watch a little slower, hit pause on sections, look out for our announcement where this will be up, posted on YouTube, and you'll be able to do that. If you are not yet a client of Keystone and Nicole, that's my wife, Michelle, struck a chord with you, and you want to talk to us about working with Michelle, I'll drop a calendar link in the chat, and you can schedule a quick 15-minute call with me. I'll talk to you about how wonderful she is. I'll brag about her. I'll tell you about her process and everything. There's no cost for that call. It's just a quick introductory call. Feel free to schedule that anytime with me that works for you. But we'll wrap up here. Thank you, everybody, for coming.
Thank you all for attending. I really appreciate that Keystone is willing to give us some time to do these educational webinars. And it's just really valuable that you guys come to it so that we can keep doing them. So thank you for your time this afternoon.
Thank you, everybody.